Good morning and welcome. My name is Ryan Berg and I'm a senior fellow with the CSIS Americas Program. Thank you for joining us today for a conversation on what lies ahead for the Zones for Employment and Economic Development in Honduras. Before we formally begin, let's take care of some logistics. This event will last approximately 60 minutes. Following the panelists' remarks and a moderated discussion, we will field questions from the audience. Please submit questions by clicking on the Ask Live Questions button on the event webpage, or you can simply type your question into the Zoom chat box. Again, good morning. Thank you for joining us today for an important conversation on what lies ahead for the Zones for Employment and Economic Development in Honduras. The use of special economic zones, or SEZs, to accelerate economic growth and demonstrate best practices has been adopted by countries around the world. Some of the most well-known examples include Shenzhen, China, and the Dubai International Financial Center. In Latin America and the Caribbean, there are over 500 active SEZs, with major success stories across the region, including in Panama, Colombia, and Uruguay, to name just a few. In Honduras, the Zones for Employment and Economic Development, or Zonas de Empleo y Desarollo Económico in Spanish, also known by their acronym ZEDEs, are a type of SEZ that delegates greater autonomy to zone administrators. Adopted in 2013 as an amendment to the Honduran Constitution, ZEDEs act as special subdivisions of Honduras. Within their borders, ZEDEs are free to adopt their own taxation systems and legal regimes, crafting them to attract private capital and ensure investor guarantees. Proponents of these zones cite the major advantages of such economic freedom to adopt business-friendly practices that can stimulate economic growth within their borders. By attracting investment and creating new jobs, advocates also cite a multiplier effect for ZEDEs, with important spillover effects in surrounding areas and potentially Honduras as a whole. However, the ZEDEs have also faced heavy criticism, especially from the newly elected President Xiomara Castro, who campaigned in part on abolishing the zones. ZEDE opponents maintain that the zones erode Honduran sovereignty and are linked to the corrupt former president, Juan Orlando Hernandez. Such claims are rooted in an earlier law creating special development regions, known by their Spanish acronym RED, which was struck down by the Honduran Supreme Court in October 2012. While there are substantial differences between the two models, antipathy toward the ZEDEs has persisted, reaching a boiling point late last month when, on April 21st, the Honduran Congress voted to repeal the 2013 ZEDE law. While the vote does not mean the immediate dissolution of the ZEDEs, it speaks to the fraught nature of the current debate in Honduras. If the Honduran government moves forward, it may risk not only exposure to millions of dollars of liability, but it may further damage investor confidence in a country that needs to create more jobs to attend to its demographic growth, a youth bulge, and outmigration. A recent Gallup poll conducted in the country finds 75% of Hondurans believe job creation should be a top priority for the Castro administration, and about the same number of Hondurans in the same poll expressed a willingness to accept a job within a ZEDE. The poll did not register a belief that dissolving ZEDEs should be a top priority of the Castro administration. Today, we will unpack the thorny legal situation playing out in Honduras, as well as discuss what current developments mean for Honduras' economic future and its ability to continue to attract private capital. Finally, we will consider the region as a whole and what best practices can be drawn from the special economic zones in general and ZEDEs in particular. And thankfully, we have an expert panel to help us think through these questions. Our first panelist is Sohan Dasgupta, Senior Counsel at Shar Jaffe LLP. He is an expert in international arbitration and commercial law with an extensive career in both the public and private sector. Before his current position, Dr. Dasgupta served as Deputy General Counsel for the Department of Homeland Security, where he helped negotiate critical security and trade agreements on behalf of the United States. Our second panelist is Katia Yacaman, Senior Vice President of Grupo Carims. Katia has been responsible for the attraction of world-renowned business process outsourcing to Honduras, helping to generate more than 12,000 direct jobs in the country. Katia has been ranked in the top 15 marketing leaders for Honduras, and she was also ranked in the top 100 marketing leaders for Central America and the Caribbean by Estrategia y Negocios magazine. Our final panelist is Welby Lehman, Senior Director for Global Government Affairs at Walmart. He helps lead Walmart's Americas branch, which employs 230,000 people across Mexico and Central America. Previously, as trade counsel for the U.S. House Ways and Means Committee, Lehman managed passage of the U.S.-Colombia Trade Promotion Agreement, consultation with USTR on 14 chapters of the Trans-Pacific Partnership and Transatlantic Trade and Investment Partnership, and ongoing congressional oversight of NAFTA, now USMCA. So with that, I want to turn it over to Dr. Dasgupta. Over to you for your opening remarks.
Thank you very much, Dr. Berg. Very kind of you to invite us, and it's an honor to be here with all of you. Such a distinguished panel. My fellow panelists are incredibly impressive, and I'm delighted to have everybody tune in to our discussion today. I think that the most important thing that we need to appreciate is that these kinds of treaties, as well as legal stability agreements, they don't exist for their own sake. They exist for the sake of encouraging the Committee of Nations to help nations stay on the up and up in the community of nations, as well as to attract investment and help their people generate, because free governments and free people is often an essential predicate to having successful and stable governments and stable relationships and profound successes. And I think that it's important to appreciate from the principle of international law that a successor government always succeeds to the obligations as well and as to the benefits, and is responsible for the wrongful acts of predecessor regimes. That is a core pillar of international law. In fact, the third restatement of the Foreign Relations Law provides that the capacities, rights, and duties of a state are not affected by a mere change in the regime or in the form of government or even its ideology. That's from Section 208 of the third restatement, Comment A. And the International Law Commission's draft articles impose international responsibility for wrongful acts on the state itself. That's the textual phrase used, regardless of what one might prefer had been engrafted, rather than just on the government of the state. And the state refers to something conceptually much larger than the government of the day. This difference signals that the current government of the state is according to an International Law Commission report from 1975, the current government is responsible for obligations incurred by the state, even if such obligations were incurred by a predecessor regime. And we've seen this come up not just in the context of international investment treaties. We've seen that come up in the context of other agreements like the Algiers Accords, which led to the Iran-US Claims Tribunal. This is, of course, after the Shah's regime fell and the Islamic Republic came up in its stead, and the Iran-US Claims Tribunal, in cases like Short versus the Islamic Republic of Iran and other decisions, the tribunal said that where a revolution leads to the establishment of a new government, the state is still held responsible for the acts of the overthrown government insofar as the latter had maintained control of the situation or anything like that. Because otherwise, what would happen is that the change in government would lead to the nation breaking its word. And I think that moving it to the context of the change in Honduras and what that's led to with respect to the ZEDEs, is important to appreciate that the legal stability agreement that was in place there made sure that even if a subsequent government of Honduras tried to get out of the terms of the legal stability agreement, then there would be they would go through the transition period. They would go through all the proper formalities, and there's a difference between repealing the protections that are given to ZEDEs and other autonomous zones than rather than just rescinding it, because all of this leads to a certain vitiation and diminution of the rule of law and the stability on which people can rely. I think that an important point to appreciate is that Honduras owns its institutions, its agents, and its instrumentalities. So property institutions, the Supreme Court found twice that the system was legally permissible, the ZEDE system, once in 2014, another time in 2021. In 2021, the court the Supreme Court established the ZEDE court system, recognized the ZEDE court system, forgive me. And then there have been about 7 legislative acts populating the National Oversight Body, CAMP, ratifying the Kuwait Treaty that protected investor rights, liberalized banking laws, authorized banks chartered outside ZEDE to operate within ZEDE, a law in 2021 authorizing the executive branch to enter into additional LSAs with the ZEDE. In 2016, the legislature identified the ZEDE framework as a promoted sector of the economy. The legislature in 2016 also clarified that ZEDEs cannot provide tax incentives solely to diminish out of ZEDE tax base, and rules concerning sales tax. So the fact that Honduras owns its institutions and that those institutions have ratified the ZEDE system makes it very awkward for the same institutions or for a change in government to overturn so easily what has been the premise and the promise on relying on which investors have invested formed a way of life around the ZEDE. And every institution in Honduras have sustained ZEDEs under various legal instruments to which the government had committed itself. Whether it's a combination of these the court decisions, the legislative acts, CAFTA DR, which of course is the hook that allows much of the ensuing conversation to take place, and of course the legal stability agreement. So there had been massive reasons to rely on it. And also a related point to all of this is that this is kind of a canary in the coal mine, because a lot of investors, government, stakeholders all over the world, the international community, they're looking to see all over the world what's happening in Honduras with the ZEDEs. This is going to set a certain kind of precedent. It's an investment framework that's a prominent one, and it's what we do, what happens here, and how this is engaged with, how this is dealt with, is going to matter a great deal. So I think that we need to proceed carefully, we need to proceed thoughtfully, and we need to proceed with the bigger picture in mind, rather than precipitously. I think that a point that I should mention is that the Castro government repealed the maquiladoras protections. That's a huge sector of the economy. It has expropriated electrical generation industry and other changes that have been going on. And those are important to appreciate, important to incorporate, because for the last 10 years, the since the amendment to the Honduran constitution occurred, these ZEDEs have been acting as special subdivisions, and within the borders of Honduras and within the borders of their own autonomous zones, they have had the liberty to adopt their own taxation systems and legal regimes, subject to certain kind of oversight. And in Korea, in the United States, in parts of Africa and Southeast Asia, as governments contemplate what happens, as governments try to attract investment in order to improve the lives of their own citizens, with regard to anti-corruption, with regard to significant concerns about bribery, crime. The ZEDEs have been kind of, in many respects, or they've aspired to be, and to a large extent succeeded in becoming, in being hopeful lodestars and oases. So it's important to keep that in mind as we go forward. Thank you.
Great, thanks. Thank you very much, Sohan. I will note that I was having a bit of connectivity issue with your internet, so I do hope that your connection strengthens with time. Thank you for your opening remarks. Katia, over to you for your opening remarks. A very good morning to you in Honduras.
Thank you, Ryan. Thank you so much for the invitation. It's a pleasure to share this morning with all my fellow panelists. It's an honor to be here representing Honduras on this very important conversation this morning. From my side, being from Honduras, we have been in GK, we have been responsible for the attraction of a lot of foreign investment. We are, our company is mostly in textiles and real estate. And we actually were the pioneers on helping establish the outsourcing industry in Honduras. So the first ever BPO call center types of outsourcing came to us through our project, Altia Smart City. So we're a lot into context with this special zones for development, like what the ZEDE has, the whole controversy with the ZEDE. As we move along this morning, I'll talk to you a little bit about my perspective on the ZEDEs. We have been operating for many years under Altia. To give you an example, it was used a lot as an example of what a ZEDE could be like when it was the process of getting this law instated and passed by Congress. And Altia is actually not a ZEDE; it's a smart city. We have business towers, we have a university, people work and study concurrently. There's different areas that we have a shopping center that people interact. They all create this smart concept where people can work and study. And actually we don't operate under the ZEDEs, we operate under the free zone law, so which is the SOLI law. This law was approved in Honduras in the 1970s. And it's basically the law which most of the manufacturing and maquila companies have been operating and using for the past years. I mean, this law, in my opinion, the SOLI law is a very stable law compared to, for example, I know many countries in Latin America and in the region have this law. One of the advantages that Honduras has is that we've had it for many years, and in many countries, this law is capped for a certain period of time just to attract investment. In our case, it really doesn't have an expiration date per se. So I think this is, I think what's going to happen is a lot of the ZEDEs that operate here, which are not a lot. I think it's also I think there's a lot of confusion, in my opinion, too. A lot of my customers, when this law was derogated, they came to me and they were like, Katia, how does this affect us? And I'm like, no, it really does not, because you guys are under the SOLI law, which basically allows anybody that exports a service in a service or a product into that's not being consumed in local market, they're exempt of all national, local sales tax, and it provides a lot of benefits. It also has some, there's different caps on salaries, there's different types of things. So I think in my perspective, I think definitely we have been trade partners for the U.S. I mean, we're the U.S. and next door neighbor. We have been trade partners through CAFTA, CBI. I mean, there's a lot of things that can be done, maybe to modernize some of these laws. To give you an example, when the first BPO came into Honduras, which wasn't an industry that existed in our country, they were allowed to come into the SOLI regime for them to be able to have this benefit that was only available mostly to the manufacturing companies that do all types of manufacturing, right? But since this was the export of a service, so I think there's a lot to do, and I think some of the CEDEs that operate now could keep on operating still under the free zone law, and they would still have a lot of benefits as foreign investors in the country. And I think there's a lot of things that can be done as an industry to lobby for certain kinds of changes or modernizing this law, to have certain aspects, of the CEDEs, the positive aspects of the CEDEs to be made into a modification of this law, rather than many of the broad aspects of the CEDE law, which many people in the government, the current government, were not supportive of. So I think that there's a lot to be done. I really don't feel this would really impact. Of course, we talked about rule of law. That's something very important. Definitely with these changes happening in the midst of this new government, these are things that definitely foreign investors look at. But really, in terms of attracting new investment, of current investment, I think we're still pretty stable. And I think there's a lot of confusion between both regimes, which can actually operate in a very similar way to provide impact and benefits for foreign investment in the country. Thank you, Ryan.
Thank you very much, Katia. Welby, over to you. You've spent a good chunk of your career thinking about what makes countries and also geographic spaces economically competitive. So over to you for your opening remarks.
Thanks. Yeah, I think that a special economic zone that is intentional from the beginning about it really being a special development zone has done the first part right. In some ways, basically, what we need to recognize is that many concerns about SEZs, and even when in the very early history of free trade zones, has always been, in fact, its special nature potentially being a distraction from, or pull away from, or race to the bottom versus the general regime of a country. And the opportunity here is to explicitly marry the SEZs and their long history, starting with free trade zones, with this modern understanding of stakeholder capitalism that has developed, and say that basically what is special about special economic zones is they are for investors that have a special commitment to partnering for the public good, or the cluster of public goods that make up development. So that is a lot of people, the first thing they think about if they think of a special economic zone is, lower or non-existent tariffs or lower regulatory burdens. Let's also think of it as higher obligation, and make it as explicit as possible, higher obligation to do that work of the co-generation of public goods around institutions, using in particular, I think, Douglas North's understanding of development. That is, that it comes down to the strength of institutions that are bundles of formal and informal norms, or cultural norms, and enforcement or accountability mechanisms. And so basically, the looking back after a certain period of time, an SEZ should have contributed, not just in its own space, but to the entire nation and its citizenship, improvements in formal legal norms, informal cultural norms, and enforcement practices. I think that there are a number of ways, I can get into it later in Q&A, a number of ways in which that can be done. But I think that, let's be clear in the same way that a board is clear with its management about what the top line expectations and goals are. Like, there's a lot of opportunity for, and in fact, allowing a million flowers to bloom in how you implement those expectations is a very good thing. But I do think that we need to be clear and demanding with regards to the expectations on the top line. If it's clear that we expect development, then in an OIRA sort of sense, there ought to be a development impact statement from the start explaining how every aspect of the governance structure of an SEZ and the other aspects of an SEZ will contribute to development in a searching way. That impact statement should be serious, and there ought to be serious measurement and evaluation to see that that's part of an actually that's part of delivering a strong institution, that there's accountability. A lot of government policy doesn't have a lot of accountability behind it besides periodic voting. But the SEZs can contribute as a public good, a new culture of like serious measurement and evaluation of whether in fact the specific governance rules and other aspects of an SEZ are in fact delivering. Another aspect of this, if we're serious about development and we're serious about Douglas North's formal norms, informal norms, and enforcement or accountability mechanisms being what a strong institution is, then we're going to, I think, quickly recognize that competition and inclusion are two central elements of this. An SEZ that contributes to a sort of separateness rather than over time a greater inclusiveness in the economic activity of a country is probably not and ought not to get great measurement and evaluation scores. And so you're going to need mechanisms from the start for sharing and actually literally contributing public goods back to the nation. I'll give an example. An SEZ that decides that because of corruption in a country, licensing and permitting is intentionally sclerotic so as to develop opportunities for corruption or for other reasons isn't working, would be wise, I think, to propose a digitalization of licensing and permitting, a single window, a platform that is both IT and capacity, and once developed, to offer it for free throughout the nation to the extent the voters and their elected representatives find it attractive. That is an actual contribution, an incubation of what can be a very expensive and technically demanding tool back to the generalized regime, so to speak. That's one example. And I'll leave other examples for Q&A, other than to say that many SEZs are far short of the sort of productive clusters that we know give rise to the best form of inclusion. Real economies are bundles of sectors. And so in particular, I'd take issue with those SEZs that are explicitly focused, let's say, just on one sector, just on manufacturing, let's say. They will invariably fall short of their potential with regards to inclusion and with regards to other indicia of development, because that's not how real development happens. The integration of services and manufacturing, they feed each other. And so, an SEZ in its development impact statement ought to have that integrated vision of productive clusters and seek to improve the integration across sectors that the country in which it's based has.
Thank you so much, Welby. That's a really, really useful set of statements on how SEZs in general can be drivers of best practices. It's extremely useful, and you even got a mention in of Douglas North. So bravo. So I want to bring this back to ZEDEs in Honduras in particular, and ask Sohan a question now that we're beginning our moderated portion of the discussion, because I heard all of your opening statements, and I think that there's still a lot of legal matters that need to be discussed here, and so a lot of this is very technical, and it's good to ensure that we're all on the same footing before we proceed in the moderated discussion any further. Now, the decrees passed by the Honduran Congress in late April and supported by the Castro government say that they repeal the laws authorizing ZEDEs. But importantly, they didn't say that the ZEDEs were rescinded or dissolved. So as legal entities, it's my understanding that the ZEDEs continue to exist and continue to operate more or less normally until they've been, quote, dissolved. Now, first question, is that correct? And if so, what would the Honduran Congress and the Castro government need to do in order to actually dissolve the ZEDEs and force them to physically cease their operations?
Yeah, well, good. Thank you, Ryan, and it was great to hear everyone's remarks. So I'm very appreciative of your time. So I think that with respect to you mentioned the point about getting everyone up to speed on the legal issues. I think that whether or not you look at the core legal issue as one of expropriation or fair and equitable treatment, minimum standards of treatment, most favored nation, and full protection and security, whatever you do, it's the requirement has never been that there has to be an official dissolution decree passed by the legislature in order for the dissolution to become effective. It need not be a per se dissolution. It can often be what we say regulatory expropriation, dissolution, or a creeping one, meaning that it's done in a step-by-step incremental basis. So whether or not they enact a formal statute in throwing the ZEDEs out of Honduras, that's not really the standard that we look to. If the basic steps are such that they burden the ZEDEs in a manner that the ZEDEs cannot function in a way that they had counted on being able to function, and they had received the legitimate expectation, as we say in the law, that they would be able to function, then that's a problem in and of itself, and that's a legal problem in and of itself. So it needn't be per se. It can be regulatory or creeping, so long as the burden is such that the ZEDEs are encumbered in an adverse manner.
Thank you, Sohan. Katya, I want to ask you, because you mentioned the difference between the SOLI law, which is more a zone that's the creation of zones that are more limited in terms of what they offer, with less sort of local autonomy as the ZEDEs in Honduras. I want to ask you to explain to the best of your knowledge for our listeners what the difference is between this law and the ZEDE law, because I think ZEDE operators would very strongly believe that there is something special about ZEDEs to sort of go above and beyond in terms of the provision socioeconomic goods, of public goods in the way that Welby was explaining, as kind of like a best-in-class practice that can have spillover effects, et cetera. So to the best of your knowledge, can you give our listeners a response that elucidates some of the differences between these two laws? And then in your opinion, since you're on the ground in Honduras, I'd also like to ask you, what are the best, average, and worst case scenarios for ZEDEs moving forward?
Thank you, Ryan. Yes, definitely there is a difference. And I read the question in the Q&A from the attendees this morning. And yes, there is a huge difference, of course. With the ZEDEs, there's much more that can be done that what can be currently done under the SOLI law. And well, the free zone law is basically foreign companies that come to invest into the country, into Honduras, they're exempt about national, local, sales tax. So it's mainly to be under a free zone law, basically the requisites you have to, of course, apply. You have to get your free zone permit. And one of the main requirements is that whatever you are producing is not for the local market. So it's something that needs to be exported. So for example, in Honduras, we have many textile companies. We have many maquila companies, which they mostly produce and manufacture. And all of this goes out of the country into different markets, right? Mainly the U.S. market. We have many advanced manufacturing companies in Honduras as well, which they produce parts for cars, microconductors. So we have big Fortune 500 companies like Lear, like Aptiv. So these types of companies also operate under. So it's advanced manufacturing as well. And in the case of what I was explaining in my opening remarks, a lot of nearshoring companies operate under this law as well, which are outsourcing companies like BPOs, ITOs, any type of outsourcing, KPOs as well. They operate under this law as well because when they take these calls, all the services, back office, shared services as well. So it's really a lot, of course. To answer your question, Ryan, the ZEDEs would allow you to do much more, right? So there was a point, for example, that we were considering, should we change it to a ZEDE, right? But of course, because everything it was very political. That was a very, very political here, something very political in Honduras. So we didn't feel it was the best way to go because of everything that was transcending. And at the end, well, they repealed the law. And definitely the ZEDE allows you much more things. You can make, you can decide on the salaries. You can decide on have your own a security police force, your own sort of government within. You're not upheld to all of the different permits, for example, to start operating in the country. So there's a lot of things that the ZEDE allows you to do. But what I think, in my understanding, Ryan, is that all of the ZEDEs won't be abolished. They'll continue to operate, but they'll be limited to many of the things that they were open to do. But that's what I was saying. I still feel that, they can still operate under the SOLI law. They'll probably need to apply and be part of the free zone law. And they'll be able to have these tax exemptions, which are really positive. And again, I think a lot can be done. Just talking about what's happening now, right? We all know the China situation with the U.S., right? There's a lot of right now. It's very hard to source jobs in the U.S. So actually, nearshoring has grown a lot in the region, right? I always say the region. Especially, right now with for example, the Partnership for Central America, it's pushing a lot of investment into Honduras, right? A lot of nearshoring. So I think there's a huge opportunity now. There's a huge opportunity in advanced manufacturing, in food processing industry, in medical devices industry, which we are starting just to do. And all this can also be done under the free zone law. I think there's a lot that can, like I said earlier, that we can lobby to make changes to modernize this law, which has been operating since the 70s, right? So I think there's things that can be done, which we can give some of the benefits of the ZEDEs and to make this law a little bit more attractive, right? But not everything that the ZEDE embodied, which some people were not comfortable in the government and in the country. And I agree. I mean, I think it's very political. I think it has been sold the wrong way to the Honduran people, as being part of a company that works 100% on foreign investment. All of our clients are mostly U.S. customers, and they're all, I mean, just with the BPO industry, we have generated more than 20,000 jobs that didn't exist 10 years ago in the country, where people can work and study at the same time. A lot of the young population in Honduras are now have this huge benefit. I think there's a lot more. This is a key time especially for the Northern Triangle countries. I think this is a key time because of I think the U.S. more than ever wants to rely on us as being even a stronger trade partner than we were before. We know everything that happened with the value chain right now, and transit times, everything that happened with COVID, that really gave a lot of importance into the region. And I know the U.S. wants to invest much more to have us as their neighbors, producing much more for them. And I definitely think there's a lot that can be done between both countries to make the current trade. There's a lot of trade agreements, right, between both countries that I think can be modernized. So there's, I think, a lot that can be done to strengthen this relationship and create this momentum that I think both of us, we've been natural trade partners forever, that really can grow right now. And I think so I think people are very, very set on the ZEDEs and then being abolished. And I'm not saying that there's a lot of benefits, but I think there's a lot that can be done where people in the government would probably feel more comfortable making all these changes than something that was so broad for them as the ZEDEs were.
Thank you, Katia, for elucidating the differences between the two laws. I think, knowing the ZEDE operators and some of what they're trying to achieve, they'll probably say that they're still, would miss something if they would start to operate under the SOLE law. But I noticed that we're getting a ton of questions in the chat box on Zoom, and so I want to transition to the Q&A portion of this event. I'm delighted that we've generated a lot of discussion, and Katia, you've given me the perfect segue into the first question, which is actually about nearshoring. It says a bipartisan bill, the Western Hemisphere Nearshoring Act, has been published and may come before Congress as early as this summer. If enacted, it will provide funding from U.S. development banks for companies relocating their supply chains out of the People's Republic of China and into Latin America. Do the panelists see an opportunity for SEZs like the ZEDEs in Honduras to play a role in attracting new opportunities as a result of such a bill, as well as organic nearshoring in general? And Welby, I'll let you take a shot at that first, since we haven't heard from you yet, but then I'll allow Katia and Sohan to respond as well, if you have something to say.
Well, first, just on the general point, clearly nearshoring is a huge opportunity in the Americas, given the size of the U.S. market and the lessons about supply chain resiliency that were learned in the COVID context, where I think most companies are going to recognize the need to have a resilient and diverse supply chain. So there are opportunities in especially Latin America, but rule of law and its weak institutions in Latin America could fritter away that opportunity. And so to the extent that what you were looking at is, consistent with my opening comments, if what you were looking at was how do we challenge the SEZs to help contribute to rule of law so that my country, whichever one it may be, Honduras or another, can in fact gain this potential opportunity rather than frittering it away due to weak rule of law. What would be necessary there? Actually, the example that I gave earlier of, let's say, building out an otherwise expensive and technically demanding digital platform for key regulatory areas, licensing and permitting, the e-invoice, many also procurement systems, digital procurement systems, and so forth. Building those out and contributing those into use by the full economy rather than just within an SEZ would in fact be really quick, big bang for the buck with regards to rule of law and predictability of a sort that could help the entire nation harvest the opportunity that's represented by the nearshoring push within the United States politically and the resiliency needs of the private sector around the world. There are, I think, other opportunities to contribute to rule of law as well. As I mentioned, just a commitment to rigorous measurement and evaluation, which, when I say rigorous, like every SEZ, I think, should have a serious set of partnerships with journalists and with universities in order to do the sort of active study and improvement within a development context. And if that sort of thing is happening and it's being contributed out as a public good to a broader set of influencers and policymakers in a country, I think that will also contribute, not quite as quickly as the digitalization of regulatory systems, but quickly enough to deliver upon, not fritter away, the nearshoring opportunity. The one that's longer term, and that frankly I don't know whether it produces immediate enough results for how quickly nearshoring will either be lost as an opportunity or gained, but that could generate the hope and expectations of progress that encourages attraction of supply chain, both services and goods, would be the people side of it. I'll use the example of my experience with Indecopi in Peru in the 1990s. Indecopi was a super regulator of sorts from several different angles, but competition policy and intellectual property being the main ones. And in that context, there were certain key regulatory processes that they decided to use a franchise model for. So this is a government agency that created relationships with, let's say, the University of Piura to run registries and so forth. The longer term effect of that was, even though that was sort of like in some ways a special regime, was both to enrich Indecopi's own capacity, because suddenly you had people at a university which had sort of the franchise for the northern area for Piura, which is in the north of Peru. You had them gaining expertise such that they could be leaders over the longer term, but it also resulted in just a huge flow into the general economy of technically trained people. And I think that that's an important component. I was in Costa Rica over the last few days, and again saw data that's responsive to Costa Rican government surveys that say investors, including ones that are who are engaged in nearshoring, listed talent and people capacity as sort of the number one reason to choose Costa Rica. And so whether or not the timing question, because training, of course, takes a lot longer time than, let's say, building a digital licensing and permitting system, whether or not the timing works, it's better to get started now, even if it's not in perfect time for the nearshoring opportunity.
Thank you so much, Welby. We've got a couple legal questions that I would like to direct at Sohan, but I've noted that he's having some camera issues. So we'll wait for Sohan to come back after our audiovisual team helps him get his feedback. And in the meantime,
well, I can hear you guys. I can, I'm just trying to see if this camera thing is gonna work.
Sohan, let's wait for you to get your video back, and then I'll give you a legal question. And in the meantime, let's go over to Katya. I have a question about China specifically. It follows on from this conversation about nearshoring. We've seen China talk a lot about SEZs. The Chinese are getting in on the regional action, but their idea of an SEZ is very different from what we've been discussing this morning. In El Salvador, for instance, we've seen the development of an SEZ that could allow China to operate something like 14% of the country's total territory and some of its most important coastline. So are the types of SEZs in Honduras and in specific ZEDEs, can they present a credible counteroffer to this kind of Chinese-style SEZ with tighter restrictions on what kinds of companies can compete and with capital that is generally, let's call it Western in its orientation?
Yes, I think definitely what we can see right now with what's happening with our neighbors in El Salvador, I think that's an example of a little bit of what our current government is afraid of. And I just I was reading some of the questions in the chat, and I think there's I don't think the exporters, I just wanted to clarify that I don't think the Exporters Association of Honduras is against the ZEDEs. I think the Exporters Association was in favor of the ZEDEs. I mean, we are in favor of anything that helps promote and make foreign investment easier. I just wanted to clarify that. This has been mainly something, again, it has been, in my opinion, something very political, and it was something very tied to a political campaign. We have an opposing party now in government versus the political party that just exited the government. So we have a brand new government, and as Ryan mentioned also in his opening remarks, this was a campaign promise as well for them, that they were gonna repeal this law. So I think nobody in the private or exporting service is against this law, and I think a lot going back to your question, Ryan, I think what happened in El Salvador is specifically what a lot of people in Honduras are scared of that might happen. By giving, and again, I think going back again into nearshoring, which I think is very important to your question. Right now, we're seeing a lot of interest from Asia, right, into coming into the region and trying to partner with the region. There's a lot more interest than there was before, for sure. So I think this is also what has opened up the U.S. interest to invest more in the region, being neighbors, being trade partners for such a long time. So I think definitely something can be done in the sense to make not exactly a ZEDE, but something that can be worked, I think, with our trade partners, that can make more opportunities for investment into the country under a different something definitely like what is happening in El Salvador. I don't see it happening in Honduras because it's much more open than what the ZEDEs currently were offering in Honduras. So I think there's a lot of groundwork now. There's a lot of interest in different industries that are not in the country, that can open up our talks between the U.S. and Honduras, especially being the largest trade partners, to grow and do much more things here that are being done in Costa Rica, like you mentioned. We can see just Costa Rica is a perfect example. Costa Rica has been exporting services for more than 3 decades now. They're moved into more high-tech manufacturing. And why? Because of investment. A lot of private-public initiatives through the Inter-American Development Bank, to the World Bank. So there's a lot of things that can be done now to strengthen Honduras as a trade partner that doesn't have to go through the ZEDEs. It's not, I mean, my point of view is the law was abolished, so now we need to like move forward, right, and look for other ways to keep on growing investment. So I think there's a lot to be done. Just to give you an example, Mexico, Costa Rica, they're huge exporters of food processing industry, medical devices, life sciences, which were just burn diapers and that here in Honduras. And it's mostly because it hasn't been promoted the right way. That's the way it happened as well with the outsourcing industry. When the first BPO ever came here, it wasn't being really promoted, Honduras as a destination. So I think by strengthening these partnerships, these trade agreements between both countries, there's a lot that can be done there to create a model that can be like a ZEDE model, but that can be more into what would make the current government more comfortable.
Thank you, Katia. Sohan, I realize we have you back. I think you're on your phone now. I want to ask you the legal question.
I had to switch tacks.
Great. I want to ask you the legal question that popped up in the Q&A, which I think is a really good one. And I want to throw this over to you. If the reversal of the ZEDE law were to be ratified in 2023, again, in order for the rescission to happen, according to Honduran law, I think my understanding is they'd have to pass it again in the next Congress. So there isn't this sort of dissolution, as I mentioned before, of ZEDEs. What are the various potential damages that ZEDEs could claim? In what court, and what levers would the ZEDEs have in order to collect those presumed damages?
Yes. Well, thank you very much, Ryan, and thank you to the folks asking the question. I think I would like to start by mentioning that it's kind of it's very difficult to assume that we can, that they can just invoke the ZOLI law and become a ZOLI, because ZOLEs do not offer a common law. They don't offer a reciprocal regulatory platform or environment with access to an improved US quality, if you will, dispute resolution system. And all of that is actually driving investor interest because it makes nearshoring far more attractive. So I should start with that. And I think that you then several of the autonomous zone entities like Prospera, they have invested more than $30 million US dollars in Honduras to organize, promote, develop Prospera ZEDE. They've raised $60 million since August of last year for investment in Honduras over the next 6 to 9 months to build out the infrastructure needed for an international financial center, robotic manufacturing, high-skill employee leasing, medical tourism, advanced energy projects, all those kinds of entities. And so to have, this hanging over Prospera or others would kind of be like a sword of Damocles that, in next year they might repeal the law or something like that. I think that you asked a very good question about what the legal recourse would be. I think that under CAFTA DR, there could potentially be, and I'm not saying anything that is not knowledge in the public domain already, because it is a international investment treaty, like many other international investment treaties. It has, as I've mentioned before, fair and equitable treatment, full protection and security. It has the non-discrimination guarantees like national treatment, most favored nation treatment, fair and equitable treatment, and so on and so forth. Expropriation, of course, then within expropriation, you have related to expropriation, you have due process, you have compensation, those kinds of guarantees. So I think that the natural forum for something like that would be the ICSID or UNCTROL. ICSID's obviously based in Washington, D.C. That's the International Arbitral Fora that is typically considered to be investor-state treaty arbitration. Each side, the sovereign, the claimant, and then there's the sovereign respondent, who each pick one arbitrator. Then the two arbitrators from the collegium of arbitrators. Then the two arbitrators get together and pick the third arbitrator, who will serve as the president of the group, presumably. The arbitration proceeds. It can be resolved in 9 months. It can be resolved in a couple of years. There are interlocutory awards, and then there's finally a final award. And frequently those awards are confirmed by the U.S. District Court for the District of D.C. So that's the general route. And I believe there was a question about compensation. So in order to figure out what the damages were, that will be the amount that the court would the tribunal would award to the injured claimant if that's the determination. If that's the liability determination of the tribunal. Sometimes tribunals use different kinds of formulas depending on the complexity of the case. Some of the energy project cases in international arbitration can be a little complex, so it's difficult to know exactly how much damage, how much injury, financial injury was caused. Do you look at prospective future injury? Do you look at other things? So there are various formulas that the tribunal would use. So yes, that's the sum and substance of it.
Thank you, Sohan. In sum, it's very complicated from a legal perspective. Welby, I want to give you the last word. You made another intervention after you finished your remarks on nearshoring. You made an intervention in the chat box. I want to give you the last word here and ask you to further some of the remarks that you made in the chat box, and then put one final question on it as well, which is, the Biden administration is talking about root causes and going after irregular migration from the region, trying to partner with the private sector, as Katya mentioned, the Partnership for Central America. So is there any way that the Biden administration should be thinking about SEZs as nearshoring opportunities in the region as well? We discussed the bipartisan congressional legislation, but if you have any comments on the administration and some of their goals and objectives, that would be great. Over to you.
Thank you I love that you tied this into root causes of migration, because it's the real pressure point at which we get to prove both the authenticity and the effectiveness of our ideas, whether in the SEZs or elsewhere. Why? Because it's about individuals, people making decisions based upon their own experience in a country, seeking sort of what is the great universal goal, which is hope for a better life. And so there's a reason why Walmart is heading into the Summit of the Americas, seeking to be represented by an MSME, a small supplier from Central America, because if our stuff works for someone like that, for a citizen, for a small supplier, then it works. And if it doesn't, then it probably doesn't. I would say two things. One, I would say two things about this connection to citizens, both in their economic capacity and their political capacity. The first is what I noted about nearshoring, which is the vast number of jobs in an economy are in services. And as we have seen in the US-Africa relationship through AGOA, if you think of nearshoring or any other trade relationship from a goods-only perspective, you will underperform the potential. You must have a goods and services vision, both because services is where, for many citizens, the opportunity for jobs and progress reside, and also because services are critical to an effective trade sector, an effective goods or manufacturing sector. But a second thing is, in this provision of public goods by an SEZ, or for that matter, by any investor, whether domestic or international, to the citizenry, we need to continually think about all of our economic activity, and for that matter, our public policy advocacy, through the eyes of these individuals, our customers, our suppliers, our associates, those who work for us. If we do that, for example, I'll give just one quick example. If we do that, it will be obvious that, let's say, that digital licensing and permitting, that e-invoicing system that is billed out as a public good, will not be viewed just as a sort of doing business type project, something that is delivered for businesses, both domestic and international, but also for citizens. How many citizens in Central America have all the permits for their homes? We need to deliver upon that. We need to deliver upon it for the MSME supplier. In other words, an e-invoicing system had better be mobile friendly, because we can't expect every MSME supplier to be able to come in from the field, sit at a desktop, or just give orders to a core of accountants and lawyers. So this is the sort of thinking that needs to go into bringing to ground, in a root causes way, contribution to citizens of the work of SEZs, which frankly is the work of all of us.
Wonderful. Thank you very much, Welby. I think that, clearly your CSIS has hit on a very important issue with SEZs, as well as in particular with ZEDEs in Honduras. And we will continue to do work and analysis on this issue. I do apologize to the folks whose questions I was not able to get to in the chat box. I think we've set off a very interesting and impassioned debate, as evidenced by the fact that we didn't get to all of the questions, and that the questions were quite dynamic. And so we will continue our work in this regard. We'll continue to produce analysis and podcasts, commentaries, and critical questions. But for now, Sohan Dasgupta, Senior Counsel at Sher Jaffe LLP, Katya Yakaman, Senior Vice President of Grupo Karims, and Welby Liebman, Senior Director for Global Government Affairs at Walmart. Thanks so much for spending your morning with us in this conversation. See you next time.